Why, hello there. We are in the last step that can be applied to all three branches of the choice of law analysis. And the last step is something that I realized after going through everything. These are always asks, so it makes most sense to remember it as part of the entirety of the framework, so you don't have to remember, oh, when do I change it? This is always applied. Always. So if, as long as you do it at the very end, it allows you, one, to either argue in the alternative, or two, make sure you collect the rest of the points so you don't miss anything. So the the W comes from the way in Eaton Way. So there's two limitations on your result in a conflict of law analysis. And one of those is either going to be constitutional limitations or public policy. Now, the limitations on constitutionality regarding the law that you choose involves one, due process, or two, full faith and credit clause. Now, due process is really just going to be a level of fairness. So specifically, when you look at due process for conflict of law, what you really want to ask yourself is, if the person was treated fairly in the litigation process, did they have a chance to fully and fairly litigate their case? Did they have a chance to fully and fairly represent themselves? How do you know this? Did they show up to court? Did they file the motions? Were they aware that there was a case going on that involved them? Did they have service of process? Did all of these things happen? If the answer is no, then they probably had a violation of due process here. If they have a violation of due process, then we're probably not going to enforce the law the other person wants, or even allow the suit to continue in the first place. Now, when you're looking at that too, if they did have a chance to litigate fully and fairly, right, then you have to ask, okay, why is the law applying the law that they're applying? Because sometimes it's not a matter of the person didn't have a chance to litigate. It's a matter of the law itself that's applied. You're like, what do you mean? Is the law that we're choosing to apply simply because as a state we're biased towards our own law? If the answer to that is yes, that's a violation of due process. You have to apply the law that you have more significant contacts with that plaintiff or transaction or something along those lines, or there's some level of aggregation of contacts, meaning that when you add up all of the things together, it makes sense. So pretty much the easiest way to look at this is, does it make sense that you're applying this law? Is there enough teeth or skin in the game for you that if you apply this law, it wouldn't be fundamentally unfair to the other side? If the answer is yes, you're probably fine. You just have to make sure you can prove enough that it's not just mere bias. If it's mere bias, that's very unfair to the other side. There is an exception or a clarification, I guess, if you will. You have to ask, is applying the law fundamentally fair? And is it not arbitrary? If applying the law of one state is arbitrary and fundamentally unfair for whatever reason, you cannot apply that law. You're like, how does this go into the end of a choice of law analysis? Let's say choice of law analysis told you at the end of the second restatement that you're going to apply California law because they have more contacts. And the exception didn't apply. You're like, okay, so we're going to apply California law. However, constitutionally speaking, even though that person had a chance to litigate or would have had a chance to litigate, the law that is applied would be arbitrary and fundamentally unfair to them because there wasn't enough aggregation of contacts to actually use this law or enforce this law. And when you really look at it, it really violated due process because another law had just as much teeth in the game and should have been at least considered, and it wasn't. Or another law wasn't applied because, you know, the individual never thought to argue it because let's say that they're an indigent defendant and they didn't have an attorney. It could be a violation of due process. If the only reason that California applied their law is because it was easier for them to do, and they didn't want to apply the other law and they didn't feel like it, if there's anything in the fact pattern like that, even if your restatement comes to the conclusion that you would have applied California law, because of their conduct, you could say, well, even though we would have applied them here, it would be very arbitrary and unfair because they were clearly biased and it was clear that the defendant didn't have a chance to fully litigate or fully represent himself in the way that he should have or didn't have the opportunity to do so because he didn't have an attorney or whatever. You can make those arguments. It's very rare that'll come up. So typically what you would say is something along the lines of they had a chance to fully and fairly litigate, and it made sense that they applied this law. It was not arbitrary, it was not fundamentally unfair. Additionally, they had significant or substantial contacts enough to, substantiate the fact that they used this law. There's a case that helps with this. It's called the Durfee case, and that's where there's a property dispute they were suing, and the point of contention was that he sued on appeal, or he filed another state for appeal, or he filed another state for another case, another lawsuit. It doesn't matter about what happened in that part, but what happened in the end was important because he tried to argue due process. He loses. Why? Because he was already sued, and he went to court, and he filed motions, and he argued on his behalf. He had a chance to fully and fairly litigate. There was no other indication that they did so arbitrarily when applying the law that they did. There was no level of unfairness because first, he never argued once that he didn't care, that he wanted a different law to be applied. So it's kind of hard for the state to be held to have violated a due process claim regarding the law that they applied in the court if the guy never brought it up. And he also showed up at the court hearings. He also litigated. It's very hard to argue against that. Now, the secondary consideration for constitutional limitation is the full faith and credit clause. This one's actually a lot easier than it sounds. All you have to ask is, was the state respecting the other state? Were they cooperating in the way that they should? They don't have to always apply another law. You just have to ask, did they violate another law's, did they violate another state law to be disrespectful? Did they violate another state law because they didn't want to cooperate with them? Or did they apply the state law that they thought was best to the situation, and they didn't do it out of spite? They didn't do it to disrespect anybody. They didn't do it to harm any type of cooperation between states. And there was no harm done. They obviously were cooperating the way they were supposed to. There was no indication of disrespect. Then under the full faith and credit clause, you're fine. There's no issues. Now, why is this under the last section? Because sometimes you can change an analysis' answer based on if there was a violation of due process or the full faith and credit clause. If there's a violation of the full faith and credit clause, you can easily say just because the state would have won in the end regarding the law they would have applied because there's an indication that they did not uphold the full faith and credit clause regarding respecting other states' law or another state's judgment, we're going to use their law instead. It's almost like you can use it or think of it like it could be a punishment. So if you violate a constitutional principle regarding any type of conflict of law scenario, you can potentially change your answer. Now, the second thing to consider is public policy, and this is all about fundamental public policy. There's three things that can allow a state to ignore a foreign law. Now, foreign law doesn't necessarily have to mean a law from another country. It just means another law, period, than their own. So if I'm California and I have a fundamental public policy in California and I was going to apply Arizona law, but I cannot simply do so because if I apply Arizona law, it would violate a public policy that's so fundamental to my state that it would somehow impact the justice from my perspective, good morals from my perspective, or a strong policy I have within California. Therefore, I will not honor that state law and I will not enforce that state law, and instead I'll use my own. That was done in a case regarding property because the property, it was like a divorce case and they deeded property in the divorce, but one state does not have any type of authority over another state's property, and because of that, it was not upheld. I think it was the Hill case. So when you're thinking about, is there something that's so strong that changes how I would end this analysis, how I would end this, because I, as a state, am so righteously angered by the result. If I enforce your law, I'm not going to use your law, I'm not going to enforce your law, I'm not going to analyze things with your law, I'm just going to apply my own. Other cases happened in was the Catalano case. That is where a state refused to acknowledge the validity of a marriage because it violated a state policy that they had regarding incest, because it was an uncle and a niece that got married, and that policy they held to be such a strong state policy that was so fundamental to their beliefs, to justice and good morals as a state, that they refused to apply another state law to hold the marriage valid. And states can do so. So you just have to look at their public policy. And even if in the fact pattern, it doesn't seem like a state is deciding or, weighing in one favor or another about that public policy, you should always argue in the alternative regarding public policy, and you could argue whether it is a strong public policy or not, and whether it would change your answer or not. And if you think it would change your answer, then change your answer accordingly. If it wouldn't, then at least you talked about it. Sorry if I was talking a little fast. I think there's a final starting in like a minute, so I just didn't want to be loud, but I think it made me go too fast. So that's the last part of the analysis that you should hit every single time. Because just because you think you have your answer, you never know. You could be wrong, or you never know, there could be additional considerations. So hopefully that was helpful. Good luck.